everybody. This is Caitlin Beck and Garrett Steck with Haynes Winkler Boyd. We're here for the HSB 2023 Employment Law webinar series for March. Thanks for being here with us. The title of the program today is Back to Normal, Immigration in the Post-COVID Business Environment. We had a lot of changes during COVID. There's a lot going on, some updates, some things that will change for COVID that are staying, some things that are leaving. So we're going to talk about that today. Just so y'all know, Haynesworth is a full service, Haynesworth Winkler Boyd is a full service law firm. We have over 115 attorneys. We have 5 offices across the Carolinas. The one office in North Carolina is our Raleigh office. And then we have Florence, Charleston, Greenville, and Columbia. Y'all can submit questions as we go through this in the chat feature, and we'll try to address them as we go or afterwards. Just so you know, the recording or the presentation is going to be recorded, and it will be shared with you after the event. The course has been submitted for SHRM, HRCI, and CLE credits. We have to give our disclaimer that the presentation is provided for inclusion only. And as always, if you have a specific issue, you need to speak with legal counsel for that advice. We have some upcoming events. On Thursday, March 23rd at noon, will be Chris Gansoren to discuss ADA accommodation, FMLA monitoring. And then on Thursday, April 20th at noon, we'll have Beth McClellan. We'll discuss the Secure Act 2.0 and the changes employers need to know to ensure their retirement plans are in compliance. So we'd love for y'all to join us for those as well.
All right. Well, thanks everybody for being here today. It has been a while since we've had some immigration seminars on this forum. So back to normal, immigration in the post-COVID business environment as people are starting to get back to work. People are moving, looking for hiring, visa renewals, green cards. A lot has changed over the last 3 years. But we're going to start with a little bit of fundamentals just to sort of act as a refresher and then talk about some of the developments and updates that really you should be aware of that could affect any business employees you may have. So from a fundamental standpoint, who can work in the U.S.? We're all familiar with the I-9 form. We'll just kind of simplify the I-9 form, but you're either a U.S. citizen, a lawful permanent resident, and certain non-immigrant visa holders. Next slide, please. So obviously, U.S. citizen evidenced by a passport card or a passport book. FYI, the government has started issuing updated and revised U.S. passports in the last 2 months. The passport now is a little bit different. It's still blue, still the same size, same pages, but it's now have different photographs. There's basically a hard cardstock in the middle with the biographical information, plus some other security features. So it will be a new passport, just FYI. If you see something that has changed from the traditional passport, that has just occurred in the last, basically since November. Next slide. Lawful permanent residents, green card holders. It allows, green card allows someone to work in the U.S. indefinitely. It requires intent and sponsorship, either family-based or employment-based. There are no restrictions on working if someone provides the green card. As long as it's valid when hired, or if they have appropriate documentation to show that it's being renewed or extended, you can complete the I-9 form and make it one and done. I'm going to ask a quick question. There we go. Sorry. And then
I think they're just getting the PowerPoint back up. Yeah.
Yep. Okay. So next to advance 2, please. Next slide. So the big on the I-9 form that causes the most, I guess, work would be non-immigrants. You're authorized to work based upon a visa classification. Remember, it's important to note that if a visa does not provide status, status is evidenced by your I-94 arrival record. The information on the I-9 form, specifically including I-94 number and the date the status expires, it can be found on your I-94 form, which is available online, which provides not only the visa classification, the date the individual entered, where they entered, and how long they can stay, plus some other information, birth date and other status information. That is the information that goes on the I-9 that controls when you need to re-verify that employee status. So visa classifications, there are a number of visa classifications, both work and non-work. What we're seeing there's a lot of people that have not been able to travel for the last 2 or 3 years because of COVID. It was hard to get visa appointments. There were restrictions on traveling, vaccination requirements. We had to go through, basically had to argue that you met a national interest exception just to be able to travel. So now that more and more people are traveling, you're seeing a lot, potentially, if you have any international clients or international employees, even from other subsidiaries or affiliates, they're coming in for business meetings, no more Zoom calls. A lot can travel on a B visa, which can be B1 or B2, which is temporary admission into the US for pleasure or for business. On the pleasure side, you've got tourism, holiday, vacation, medical treatment, non-spouse partners. What that means is that if you have someone that is living together, but not married, may even have children, you cannot get a dependent visa for that domestic partner. So what has to happen, you have to get the primary work visa for the spouse, and then, for the principal worker, and then the spouse has to get a B visa. And that allows them to come in and out of the country. What you have to worry about in that case is status, because B, you can only be admitted for 6 months. So you must also, in order to get the visa, show you have strong ties to the country. You apply at the embassy or consulate. What they're looking for is that you are not going to just come to the country and stay here permanently. We've had people in the past that have had like a grandmother from Eastern Europe wanted to come to the United States to see her daughter and her grandchild. She was a widower and did not own her own home, was not working, and she was denied a B visa because they said your entire immediate family are all in the United States. You have no reason to come back here. So they did not issue her initially a B visa. So things to just keep in mind. Next slide, please. B1 is the limited business purposes visa. It allows people to come in for limited business purposes that do not involve gainful employment. You cannot work on a B visa, but you can come in and limited for business purposes, attend meetings, conferences, negotiate contracts, short-term training, either receiving or giving training, typically admitted for the duration of the event, which would be evidenced by an itinerary or a invitation letter, but again, no longer than 6 months. You cannot be paid if you're coming to the US in B status, except for expenses incidental to temporary stay, rental cars, food, lodging, etc. Again, strong ties to the foreign country, apply at a US embassy. In this case, you typically would have assistance from the employer, both foreign and here in the US, with invitation letters and support letters to justify the reason for this employee needing this visa to come over temporarily. Next slide. There are certain countries that do not require a B visa to travel. You can enter the US on a valid passport for 90 days. In order to do so, you have to register online with something called ESTA, the Electronic System for Travel Authorization. It's about $14 for 2 years, as long as you have not had any prior immigration violations. That allows you to continue traveling via your passport and a valid ticket. Again, there are certain countries that allow you to do that, but instead of 180 days, it's limited to 90. And the big thing with ESTA is that you cannot change status. For example, if you brought over an employee on a B visa and they were here providing training, and then you decided you needed to hire them or they needed to be here longer, you could change status from a temporary B visa to an employment-based L while they were here. ESTA, you cannot do so. You cannot get a visa, you cannot change status, you cannot apply for a green card via ESTA. So next slide. Again, some of the employment-based categories you'll see, it's an alphabet soup. It ranges from A to Z, but the employment-based, or the H-1B for specialized knowledge, we'll talk about that a little bit later with the H-1B registration, lottery registration window open right now. L1, intra-company transferees. NAFTA professionals for Canadian and Mexican employees, E1, E2 treaty trader, treaty investor for certain countries, and then some lesser situations. You can look at a J1 visitor for an intern or a trainee, or an F1 student who can work with authorization during school and after school for a period of time. So, as that was just a quick refresher on temporary status coming into the U.S. and some documents that you would look for I-9 purposes. And now I think we'll move forward and let Caitlin start with some updates.
Okay, so we've got some immigration updates for you all. To get started, this is a bit of a domestic travel update for you. So on December 5th on 2022, the DHS announced that they're going to be extending the enforcement of the deadline for what's called a real ID. It was going to be May 3rd of this year, and they're going to extend it to May 7th in 2025. So what's the real ID? This was passed after 9/11 in 2005 by a recommendation of the 9/11 Commission. And it just establishes additional security standards for state-issued driver's license. It incorporates anti-counterfeiting technology, preventing insider fraud, and then using documentary evidence to check that person to get this ID. And beginning May 7th of 2025, this ID is going to be required. And this is why this is important for everyone 18 years or older. If you're going to be traveling, going to an airport, any security check, you're going to need this real ID. If you're going to be entering a federal building, or if you're going to be entering a military installation, you're going to need this real ID. So next slide, please. That's what it looks like in South Carolina. It's a little star that you see there. And you can get this just by going to the Department of Motor Vehicles. Next slide. All right, this is another update. It does affect people traveling in the US. So starting in 2023, this year, traveling to Europe is going to be different. So the European countries have banded together and to strengthen their border. The 26 members of Europe's Schengen zone will require all the visitors of the current 63 visa countries to register with the European Travel Information Authorization System, ETIAS, in order to enter those countries. So as you might know, generally you could just travel there without having to go through this process. Just so you do know, European countries that are coming to the US have to go through this similar process. It's called ESTA if they're coming to the US, but now US citizens are going to have to need this to go to Europe. So it's not a visa, it's a travel authorization. It's just a couple additional security steps that people from the US will have to take to travel to Europe. So it's a pre-screening. There's include information from your passport, health and security questions. And once you get this authorization, it's valid for 3 years or until your passport expires. So next slide. This is for Garrett.
And again, that is basically similar to the US ESTA process. It just requires a nominal payment of a nominal fee and online registration in order to board a flight into Europe from the United States. So that is something that is changing. That has not been the case for in the past, but it's not a huge undertaking, but it's something to be aware of. One of the other major changes that we've seen come up just recently has been the elimination of passport entry stamps. You can see in the bottom of the slide, there's the little blue and red oval stamp that traditionally is stamped in anybody's passport when you're returning to the US. For foreign workers or someone on a visa, it authorizes, it shows the date of admission, the category of admission, and the expiration date of that admission. That is the same information that is now contained on the electronic I-94 record, which is available online. So we are still seeing inconsistent application. We're still seeing people being admitted and stamped in with these stamps. But it's also a very good idea to encourage your foreign employees to go online, especially for those that have families, and confirm the date of entry. We have seen all sorts of crazy changes where some people's stamps in their passport don't match the online I-94. We've seen, and bizarrely as it sounds, we've seen one family go through customs recently. They all were basically stamped in, admitted into the United States, but the officer somehow picked up the wrong stamp So the entire 3 of the 4 family members were admitted in the correct status for the correct period of time. One was only admitted for like 3 months. Errors on the I-94, if basically if you can find those errors and you're aware of those errors, we can contact CBP. Most of the time we can do it via email and they can make the change in their system. In some instances, you may have to actually go back to a CBP office. For example, in the Greenville or upstate area, the actual CBP office we have is right off of Highway 14 and I-85. Larger cities, CBP staffs an office at the airport. So if someone comes into Charlotte and there was a problem that we could not resolve electronically, you may have to go back into the Charlotte CBP office to get your I-94 corrected. And again, as we started this presentation with, status is the document, or status is the date that controls for I-9 purposes, which means you're here and you're here legally. You know, just because someone has a 10-year B visa or a 5-year E visa, we look to the I-94 status and as being the controlling document. So if there is a problem, we want to get it corrected as quickly as possible. We've had people come in, especially if they've had multiple visa stamps in their passport. Somebody may have had a TN and then they moved to an H visa. The family all was admitted in TD, dependent status, and the principal was admitted in H-1B status, which legally is impossible because you can't hold TD status as a dependent if the primary employee holds H-1B status. So there's always issues, but with the electronic format now, it is something nice that can be potentially corrected. So again, encourage employees to monitor their I-9 when they travel, or their I-94s when they travel. Next slide.
Hey, Garrett.
Yes.
You had a question about the real ID being necessary for I-9 forms. I do not believe so, but we can get back to you, Jennifer. But I think the question is if an ID is being presented as a document for an I-9 form, does it have to be a real ID? And I don't think so. But
not right now. And
yeah,
from a real ID standpoint, you know, obviously you can use a passport in lieu of that real ID. This has just been almost to a point comical in how long it's taking the government collectively to do this. There's been a lot of delays on this, and it seems every time we get close, there's one more delay. Again, at DMV, it's pretty straightforward, but they do require more documentation than you would for just a traditional license. So we will, monitor that. But right now, no, you're not looking for the gold star for I-9 purposes, but you must have a valid driver's license, not an expired license for a List C document. So going back on the passport, next slide, please. So again, it's just more of what we're looking at on finishing up on the I-94 is that, again, some individuals may not have a stamp, so that may concern them. If someone comes to you and questions that, realize that all I-94s now are done online. It takes about 30 seconds to pull an I-94, and you also on the same website, once you've logged in with the information, provided the individual's information, you can also look at a travel history, which is very helpful for a lot of cases, including green card cases. You can actually see when and where people have come into the country and departed, probably for the last 3 to 5 years. So sometimes that's nice if you're ever asked for that history. So Caitlin, are you gonna pick this up or is this me?
I'm happy to take it.
Okay, go ahead.
So there has been some extensions of the green card validity. There have been automatic extensions of the green card validity, and this is again due to these backlogs that we're seeing in these processing times. And so this was a recent announcement. Just so you know, if you have a green card that is incident, you got that through a marriage, that's how you obtained it. That green card has a 2-year condition on it. And this is of course to make sure that the marriage is bona fide, etc. So USCIS announced that when you timely file what's called an I-751, which will remove those conditions. Similarly, if you get your green card based off of a qualified investment, you're going to have those conditions as well. And you have to file to get those conditions removed to have then just a regular green card. What was happening is people were filing these forms to get those conditions removed, it was taking an extremely long time. So USCIS has announced that if you timely file, you will get a receipt notice. And on that receipt notice, it'll say that your green card is valid for 48 months automatically because you timely filed that form. So that's great. And for I-9 form purposes, a person can come to you with the expired permanent resident card and then that notice saying that they have that automatic extension, and then that's going to be a list C number 7 document. So they'll still have to give you a list B document, but that's the case. And this is specifically for not someone that just has a regular green card. This is someone that has a green card that had a condition on it because they have it due to a marriage or an investment. So that's that part of it. And then for people that just have what I would want to say, just a regular green card that they've received, that's a 24-month extension. And so same situation, you timely file the form to get it renewed, the I-90, and you'll get a receipt notice that says it's going to be automatically extended. Your validity of the PRC will be extended for 24 months. For I-9 purposes, for new employees, if someone comes to you with an expired permanent resident card, but then also that receipt notice saying that they have this 24-month extension, that can be your list A document. Okay, next slide, please. Garrett, you want to do this one?
Well, this is probably, at least in our area, this is one of the better changes or developments that's occurred in the last several years, is that traditionally visas are issued by an embassy or consular post outside the United States. It's the program is run through the Department of State. You have to make an appointment, pay fees, and then go to an interview, or in some instances have a drop box where you can send your materials to the embassy for the visa stamp. Because remember, the visa stamp allows you to enter the US in a particular status, and it also ultimately tell you how long you can stay. So you have to have a valid visa and a valid passport to enter the US. And it gets to be problematic a lot of times when people are trying to renew visas, because the embassies obviously for the last several years have been either A, closed, or B, subject to selective visa processing under the whole COVID restrictions. And even now, sometimes the timing varies by country. You can get appointments in Germany generally within 30 days or less. Rome, Italy, for certain work visas can take up to a year. So obviously visa renewal has become problematic. The State Department is starting to reintroduce possibly a domestic visa renewal where we will send documents to a central Department of State processing office to actually process and issue and return a visa without leaving the United States, which is very nice. It can be, a time saver and will save money, and will also take a burden off the Department of State foreign offices processing these things. We used to do this a lot with e-visas. We would send e-visas to be renewed to Washington, D.C. And that usually would take up to about 6 weeks. So again, this is initially going to start with H&Ls. They have not announced anything further. It's something to really monitor, but it will be a cost and time saver, and probably make a lot of foreign employees very happy if in fact they don't have to go back for a visa renewal. So that is something, like I said, that's going to be happening at some point this year.
Okay, real quick, we have another question. What is the best practice to complete I-9 for extensions provided in Federal Register for TPS employees?
Generally, for TPS, you're going to wait for the designation that employment authorization has been extended. You can either re-verify, reference that in the notes, or complete, a new document, a new I-9 document, which is usually not required. The big thing is waiting for the announcement that the employment has been extended.
Thanks, Garrett. Great.
And let me see. Okay, sorry, I just was checking any questions.
Okay, yeah, no, good. Okay, so this is another change that we saw sort of definitely as a result of these backlogs that we saw with COVID. One great thing, obviously lots of horrible things coming out of COVID. There are some silver linings. With all these backlogs, they've made some kind of logical changes to a few of the processes, and this is one of them. So you have people that are E and L visa dependent spouses, they, as of, this was announced in November of 2021, but they now have automatic work authorization incident to their status. So that means solely because they hold that E or L dependent spouse status, they automatically receive work authorization, which is great. We were having to submit those I-765 forms to the people that it was automatic and decided to make work. So now it's, we no longer have to submit any form for work authorization. They automatically get it. They can of course still choose to submit that form if they would like that physical card for just various reasons, but they don't have to. How do you know that they have work authorization? So that's now going to be seen on the person's I-94 form, which you can pull from online. And there's going to be an S that indicates their work, they're authorized to work. So you can see, for example, on the slide, it will be L-2S or E-2S or E-1S, depending on that E status. So if you see that S, this is specific for those, because this is what they will present to you for the I-9 form. If you see that S next to their name, they are authorized to work. That is their work authorization. This is still just a List C document, so they still have to give you a List B document. But so you know, if someone gives you that I-94 and their status is valid and they have that S on it, they're authorized to work. This automatic work authorization does not apply to H4 dependent spouses or for H4, E, or L dependent children. Additionally, there are some automatic work extensions that have been happening due to these processing backlogs. So if someone has an EAD card, so this would be someone maybe that is eligible to work in H4 status, or even F1, they have their EAD cards. If they timely file that renewal form, they are automatically work authorized for 540 days. So again, this would be a situation where someone needs to bring to you a receipt notice that has that on it. Next slide. Okay, so USCIS announced their final phase of premium processing expansion. This is also great. Now, someone that's filing for an EB1 executive or manager, this is going to be on the I-140 form, or an EB2 national interest waiver, again, an I-140 petition, they can receive premium processing, which means that you pay an additional fee to the government, and then that form, the processing of that form is expedited. So this is great. Prior to that, EB1s, H-1Bs, Ls, and Es were all eligible for this, but now they've just included more categories that are able to file this premium processing form to get this processing expedited. And this is also, again, out of another lawsuit that was filed based off L2 and H4 dependents that were experiencing lengthy processing delays. It was a January 19, 2023 settlement. What this says is that now, regardless of whether or not people are filing premium processing or not, if you have your principal petitioner filing an H-1B form, you can also bundle with that one petition their dependents. This is great because it all just goes in together now. It was a courtesy before for people that were doing premium processing that was eliminated during the Trump administration, but now it's all going to be bundled together, which is great. It just kind of keeps everything together and neat, and everyone's processed at the same time. So of course, the main takeaway is that they're going to be adjudicating that form I-539, which is going to be for your dependents, and the 765, which is the work authorization for the dependents. That can all be put together with those principal applicant forms. And it's good for not only the families, because they're going to be kind of rest assured that it's all being processed at the same time, but then also the employers, because I know that that can also be a headache for them, because their principal employer is worried about their families getting, the correct work authorization and status. So it's a great thing that they're bundling now. Next slide. So the H-1B lottery just opened yesterday, and it'll go through March 17th. Again, just as an overview, the reason for the lottery is because the H-1B visas are capped. There's only a certain amount of them that the U.S. government issues. There's 65,000 of the regular cap, and then an additional 20,000 for the master's cap. This is now kind of a more simplified process. Basically, if you have someone that meets the qualifications, they have the bachelor's degree, the specialty occupation, there's certain things you have to meet. You pay a $10 registration fee. And then if they are selected in the lottery, the employer has a time frame that they can file this H-1B full petition, and the government will keep conducting the lottery until it's full.
Let me just kind of jump in for a minute. The reason the H-1B, there is an annual lottery, is that, again, as Caitlin said, it's a numerically limited or quoted visa, so 85,000 total H-1B visas for new employment annually with a start date of October 1. Traditionally or historically, employers would have to just prepare and file an H-1B petition. Depending on how many H-1B petitions the government's received, they would either accept or they would return them. Now it's the lottery. Last year there were over 500,000 people that applied for 85,000 visas. So H-1B is a very coveted visa. If you're counted against the cap, you are lucky. Maybe you ought to go get another lottery ticket. But again, it's something now, if selected in this lottery that we've started right now, is for the 2024 fiscal year, which begins October 1st of this year. So if there's a foreign worker that you employ who has temporary status as a student, or there's someone you want to hire and bring over to work, provided you meet the eligibility requirements for H-1B visas, you must register in the lottery. If you don't register in the lottery this year, the next lottery will be next March 1st for a start date of October of 2024, which will be the 2025, beginning of the 2025 fiscal year. So it is something that, if there is any even thought, you might want to pay the $10 and register just to at least have a chance. Otherwise, you have to wait till next year. So.
Yeah, great. Thanks, Garrett. Okay, next slide, please. Garrett, go ahead.
Just a final recent change. The naturalization test has been fairly static for many, many years. During the Trump administration, they created a new test. Then that kind of reverted back to the old test. They're trying to update and modernize at least the civics portion to include more than the current 100 questions. They're going to try now with civics, history, and geography. Discussion questions more than just simple answers. The traditional questions are who's the president, who's the governor of your state. I've seen questions recently, who was the president during World War I or World War II? What are the three branches of government? A client last week had a question about mountain ranges in the United States, rivers in the United States, but they want more discussion, more of a conversation than just, answer one simple answer or three branches of government. They want a little bit more, like, not what are the three branches of government, but why three branches of government, or what does each branch do, rather than just simply memorizing something. Because again, trying to modernize and update, this will be slowly introduced as we move forward, probably into next year or so. Again, naturalization is how someone who's a lawful permanent resident of the United States can become a U.S. citizen. It's entirely voluntary, and currently, at least in the South Carolina and North Carolina areas, taking about 6 months to 1 year, depending on which office processes it. So, next slide. Caitlin,
Okay, so there are new designs for the permanent resident card and the employment authorization card, the EAD. It's going to start January 30th of this year. I guess already started, so I guess they've already started issuing them. And the reason for this is a proactive approach to fight the document tampering, fraud, and counterfeiting. And there's new features on it. We'll show you some pictures. And the previous cards are valid until their expiration dates, or unless otherwise noted, of course. So if you see at the top left, that's the 2017 version, and then below it's the 2023 version. There's just a few different changes that you see. There's the Statue of Liberty is twice on there. There's no more the little fingerprint. The back has changed a bit. Again, just things that they've done to sort of increase that the fighting of document fraud. Those are all old cards, old designs that you see there.
And note, if you go back one slide, please, note that some of the older cards, the very older cards, don't have an expiration date. So for I-9 purposes, technically they're still legal to accept, even though they look like they were issued, and they were issued in the 70s. and they look like they could be, obviously photograph, fingerprint, but very, very little data. So obviously things have evolved and changed. Currently they're green, but it's just FYI when you're looking at documents, because the government changes these credentials because counterfeiters copy them. And so they're always trying to stay one step ahead, which was a bit easier when you look at these cards on the screen. But now, with color scanners and digital color printers and such, you can get holographic images from eBay or Amazon now. And it's, so the government tries to stay one step ahead, but it's a constant battle. But just from a standpoint, the new card has been introduced, and that will be, going forward, will be the new current card for the next few years.
And again, these are the EAD cards, the employment authorization documents. The previous one is on the top left, and the current one is on the bottom right. And this is just so you all know that these changes are happening, these new designs when you see them.
Then sort of just an update as far as increases. The government basically adjusts their administrative, civil, and criminal penalties. You can go to the next slide. Basically on inflation rate. So for I-9 violations, they have increased the range for violations. There's not just a simple, it's not a very simple penalty. Any sort of penalties imposed by the government for improper employer compliance activities, which would be I-9 failures, basically are put into a penalty matrix that incorporate a lot of different information, individual problems on the I-9 form, document retention, etc. That all goes into a matrix to determine what is the penalty per violation per individual I-9 form. And as you can see on the slide, fines range, a very significant range, from a few $100s to several $1,000s. Then what happens is, depending on first, second, or subsequent offenses, they can become significant. Sometimes the second or third offense can become criminal. If you knowingly hire and continue to employ people who are not legal, that's when administrative penalties can become criminal. And you can generally see that, unlawful employment, continued to doing so, where the penalties range. You see paperwork violations. Really, we don't see as many problems on I-9s now as we did in the past. It was amazing back even on the old one-page I-9 form. There were just repeated mistakes and issues, and every one of those is a separate violation. Not just, oh, well, this I-9 for this employee is wrong. No, this I-9 for this employee had 6 things that were wrong. Each one of those constitutes a separate violation. Next slide. Oh, okay, well, back up. I'm sorry, back up one. So just to kind of mention this is that, what we're seeing in South Carolina specifically, LLR is still continuing to issue their audits, which are generally paper or letters that you receive about E-Verify compliance. We're still seeing more and more I-9 audits, which are conducted by Immigration and Customs Enforcement Homeland Security Investigation Group. Their office is downtown Greenville in the Landmark building or the old Daniel building. But they're not as random. They don't have that many officers. Usually any investigations are a result of some sort of whistleblower, disgruntled former employee, or generally certain industries that tend to have more abuse than others. So we're seeing audits. We're seeing audits take at least a year. And then we're seeing penalties range from a few $1,000s and up, depending on size. It's a slow process, but it's still ongoing. Again, it's not every employer will not be hit. We're seeing those. We're not even seeing in-person investigations anymore. We're seeing some FedEx subpoenas that show up that basically say you've got 72 hours to turn over all your I-9 forms, your payroll, your tax records, your corporate records, and some other ownership information. So I-9 audits are out there. There are penalties associated with poor compliance. Again, we usually recommend a self-audit just to look and make sure you're comfortable with your documents. Again, Some employers use electronic I-9. Some use the form on the website, others print out forms. Also remember, if you print out forms, remember to fill them out correctly and completely, and make sure you're using the correct version. Next slide. Prevailing wages, just a comment. The government updates their prevailing wages. The DOL updates their occupational classification and wages every July 1st. And the wages usually are a cost of living sort of adjustment, you know, a few 1-2%, maybe at most. In July of 2022, the Department of Labor basically restructured and reclassified and created a number of new occupational codes, and the resulting prevailing wage, which is required for H-1B visas and permanent residency sponsorship. In some instances, we've seen a 30 to 40% increase in what the prevailing wage limits or requirements are. So all of a sudden, it's starting to become an issue where you hired somebody in say an IT position 3 years ago, and the prevailing wage level was $75,000, and now it's $130,000. That tends to be a problem. So it's something to be aware of. That causes problems not only for H-1B, but also the green card process. Next slide. This is just kind of summary what we've talked about. And again, it is something that is precluding some people from the market, but again, it is trying to justify or take a picture of the wages, and the wages are based on Department of Labor information as based on a geographical location of employment. So you can search online for prevailing wage, and you can look online for this particular occupation in this particular MSA, or you can even drill down to county level. So just be aware of that. That does impact potentially green card cases and H-1B sponsorship. Next slide. And then the biggest hit, the government published proposed rulemaking where they're increasing their administrative fees, which is basically the fees that employers pay for immigration, family-based and employment-based. Across the board, everything's increasing. Go figure. That's kind of the norm for life right now. However, employment-based immigration is increasing excessively, in my opinion. They are basically starting to decouple applications, increase filing fees across the board. They're actually adjusting fees based on the type of visa now, not just a standard, say, $460 petition fee. Now it ranges for H-1Bs up to $1,800. Ls are $2,400. That's just the base application fee. I mean, 100%, 200%, 300% increase in fees. That is, obviously the government for immigration, they're self-supporting, just like the post office. So their budget comes from their fees. They really haven't updated their fees in a while. And again, I'm hopefully optimistic that the initial comment period and the fees posted were sort of the rule 101 for negotiation. State your price high so you can negotiate down to where you really want to be. But we're looking at, like I said, potential increases in immigration fees, in some instances, several 100% increase. And remember, for example, H-1B visas, it's not just the base application. There's also anti-fraud fees. There are also supplemental fees. There are also fees based on how many foreign workers you have. There can be penalty fees. So with some of these new fee structures, it would not be impossible to have more than $10,000 for one application. And that's before any sort of expenses or legal fees would be involved. So something to watch out for, but again, optimistic that they basically started high to negotiate to a more reasonable fee structure. Next slide.
Okay, so USCIS is going to extend some of the code flexibilities that we're seeing. This one is very specific to you all. So this is the extension of the Form I-9 flexibility policy. So as I'm sure a lot of you know, since 2021, they have the in-person verification has been not required. So announced October of 2022, they're going to extend that flexibility policy until July 31st of this year. And so it's the temporary exemption of the in-person inspection of those I-9 documents for anyone hired after April 1st, 2021, who's working exclusively in remote settings due to the COVID-19 related precautions. Next slide. So just, I've gone over this before. I know some of you may have already heard this, but so when you're doing this, of course, with everything, you just have to make sure to document this well. So if you have someone that's coming on that's remote for the onboarding process, just make sure to document that there is that this person is going to be working remotely. So document their onboarding, this telework policy. If you're going to be exercising this flexible, this exemption of the in-person inspection.
Hey,
So-
let me interrupt for a quick second.
Yeah.
Let me just make one point about work from home. And again, this is going to be more specific to the H-1B program than really anything else. But this is something that has really popped up in the last 3 years for the COVID work from home, is that a lot of employers still even have the work from home policy. New positions have some flexibility. What we found out, I'll say the hard way, was that one of my larger clients had a number of work from home positions in the IT group, our IT sector, and everything was fine because there are certain government regulations that require, again, prevailing wage, location of employment, and a lot of people work from home. And then all of a sudden, through various discussions or requests for information, or just in general, the employers found out that work from home did not become local anymore. So I had a company in Colombia where one work from home person didn't tell anybody, but moved to Texas with his wife so she could go to grad school. 2 more moved to Atlanta, didn't tell anybody, because again, work from home, they were doing their work. The problem that poses for an employer is that those are violations of the LCA regulations, that they are no longer paying the prevailing wage in the location of employment, and have not complied with the notice regulations and posting regulations for H-1B employment in those areas. And it became a very big issue with one client where the prevailing wage in Columbia, South Carolina was $85,000, and in Atlanta, Georgia, it was $130,000. So all of a sudden, there was no way to employ that person at $130,000, which is the prevailing wage for that position in Atlanta metro area, whereas Columbia was significantly lower. And again, that causes a lot of internal violations, causes paperwork problems on the H-1B program, but then also questions of, payroll and such that employers had to address. So just from a work from home, again, just maybe be mindful if you have any H-1B employees where home is.
Yeah, that's a great point, Garrett. Thank you. Very good. So back to the I-9 flexibility stuff. So you still have to inspect these documents, but you just do it over Zoom or fax or email or video link or something like that. And then you just need to make sure we're still within those 3 days of hire. And then in that section 2 of those I-9 forms under additional information, you put COVID-19 as a reason for the physical inspection delay. And then you have to still conduct those in-person verifications if that person comes back to work and it's underlined here on a regular, consistent, or predictable basis. So, if the extension is terminated, so the extension being this flexibility policy. So again, still have to do those in-person requirements when that person comes back into the work, into the physical work area. If you like this policy, great, because it's probably here to stay. Another maybe great thing that came out of COVID is that on August 18th of 2022, DHS proposed a new rule that would create a framework that would allow for alternative options for this document examination. The public comment period closed on this in October, and so we'll likely see a new rule about this in this year, a final rule on this. And it might, we're not really sure exactly what it's going to look like. It probably won't look exactly what the COVID policies were, but it'll be some variation of that. The document and examination process will change in 2023. And then we have a question here. What if your HR rep is remote? Not necessarily the new hire employee, does Zoom or equivalent still apply? I think this question is asking if the HR representative is remote. I understand. Garrett, I don't know about that, and we might be able to have to get back to you, Nancy, but the question is that for this flexibility policy, if the HR person is remote, but not the employee, can you still do the documents remotely? And that would have to be all the documents, or, the in-person inspection would be waived.
Nancy, Kayla and I will be back in touch with you.
Yeah.
That flexibility to a point.
Yeah.
There's a couple more questions I want to ask you first. So
That's a great question, Nancy. I'm going to we'll write it down. Okay, thank you.
And do note, just from an I-9 standpoint, there's been 2 rumblings that they're going to make some more changes to the current I-9 form. So there may yet be another revision or addition. So just watch for that in some of your emails. And then the on again, off again, electronic combination E-Verify I-9 form is still being kicked around, but I don't anticipate any developments on that in the next year or so. But that's still a pie in the sky sort of, at some point one day that may all be a one-time, one website program, but not this year.
Yeah, and just so y'all know, we are nearing the end of the presentation, so please, if you have any questions, go ahead and put them in the chat box now, and we'd be happy to answer them when we conclude. All right, so then another COVID policy another policy that was a result of COVID was that there was an extension or an increase of time that you could respond to certain requests or notices from USCIS. And this was actually super helpful, especially with all the uncertainties of COVID and people having to send us documents remotely or it was very beneficial to have this. So what this was that the most common thing that you would see is a request for additional evidence. So this is a situation where you submit a visa petition and the government says, we're going to need more from you. We're going to need you to prove this. We need to clarify this. So it's a request for additional information after the petition has been submitted. And what this policy did was gave you an additional 60 days after that due date. So that was great. And these are all the requests and notices that applied to. And then there was an increase of 90 days for a notice of appeal or motion. And so that's when you're, appealing a decision made by USCIS. So you could respond to that appeal, or you could make your appeal or a motion to reopen 90 days after you received that from USCIS. Unlike the I-9 form situations, USCIS has opined that this is probably the final extension for this, and it'll just go back to the regular time periods after that. So next slide. That might be. So that's it. This is our contact information for Garrett and I. And yes, we can definitely share the answer to Nancy's question with you, Christine. That's no problem. I'll just write that down. And we're happy to answer any more questions that anybody might have.
But just, be aware, like I said, a lot of things changed over the last 3 years as far as policies, procedures. Some are changing, but with immigration and with compliance, obviously the requirements are still there. With immigration, you've got to be prepared for longer delays and more cost, which kind of sounds like a broken record. But that's really what we're seeing now. Processing is all over the board with USCIS and the embassies, as I've sort of alluded to earlier. You just need to be prepared and have your employee and or management be aware that things still are not back to where they were pre-COVID. And there needs to be some expectations set about timing, processing, and then unfortunately increased costs. Again, thanks for your time today.
Yeah, thank you, everyone.
Send them. Feel free to email, and we will respond.
Yeah, thanks so much, everybody.
Thanks for joining this webinar presented by Hainsworth Sinclair Boyd. To learn more about the firm and its services, visit hsblawfirm.com.